My name is Laura Bennett. I am 34 years old, and until the second Wednesday in September, I believed I understood exactly what my finances looked like at any given moment, because I have spent the last 9 years working as a paralegal for a firm that handles, among other things, consumer fraud cases. I have read hundreds of client files describing exactly the kind of situation I am about to tell you happened to me, and I always assumed, in the quiet, slightly arrogant way people assume things about themselves, that my professional knowledge would somehow make me immune to it. It didn't. It only meant that when it happened, I recognized what I was looking at faster than most people would have, and I knew exactly what to do about it. I was sorting the mail on the kitchen counter of the house my husband, Nathan, and I had bought 4 years earlier, a modest 3-bedroom on a quiet street outside Dayton, Ohio, when I found an envelope from a collections agency addressed to me, with a case number and a reference to an outstanding balance on a business line of credit held by Bennett Heating and Air Solutions. I stood there holding that envelope for what felt like a very long time, though it was probably only a few seconds, because 2 things about it were immediately wrong. The first was that Bennett Heating and Air Solutions was my father-in-law's company, a commercial heating and air conditioning business he had run for almost 30 years, and I had never had any ownership stake in it, any employment relationship with it, or any financial connection to it whatsoever. The second was that I had never signed anything, applied for anything, or agreed to anything involving that business's financing, ever, in the entire time Nathan and I had been married. I opened the letter standing right there at the counter. It described a business line of credit originated 18 months earlier in the amount of $85,000, with my name listed as a personal guarantor alongside my father-in-law, Walter Bennett. The account had fallen behind on payments for the past 4 months, and the collections agency was now pursuing both listed guarantors for the outstanding balance, which, with fees and accrued interest, had climbed to just over $91,000. I want to be honest about the sequence of what I felt in that moment, because I think it matters for understanding everything that came after. My first reaction wasn't panic. It was a very specific, very professional kind of disbelief, the same feeling I get at work when I read an opposing party's filing and find a claim so factually impossible that I have to read it twice to make sure I'm not misunderstanding something. My second reaction, once the disbelief passed, was fear, sharp and immediate, because I understood exactly what a $91,000 defaulted business debt with my name attached could do to my credit, my ability to refinance our mortgage, and potentially my own professional licensing, since my firm required periodic background and credit checks for employees with access to client trust accounts. My third reaction, and the one that ended up mattering most, was that I needed to find out exactly how my name had ended up on that document before I did anything else, including talking to my husband. I texted Nathan that afternoon while he was still at work managing a construction site an hour outside the city, because I wanted to give him the chance to explain what he knew before I let myself assume the worst about where this had come from. Laura, a collections letter came for me today about an $85,000 business loan connected to your dad's company. My name is on it as a guarantor. I never signed anything like that. Do you know what this is? Ma. His response took almost 2 hours, long enough that I had already called the number on the letter and confirmed, through the collections representative, that the loan in question had originated at a regional bank about 18 minutes from Nathan's parents' house, using an application that listed my full legal name, my social security number, and what the representative described only as the guarantor's signature on file. When Nathan finally responded, his answer told me everything I needed to know about how deliberate this had been. Nathan, Dad needed a co-signer for the loan and your credit was better than mine. I meant to tell you about it, it just kept slipping my mind with everything going on at work. I read that message twice, standing in our kitchen, feeling something cold settle into my chest that had nothing to do with the money and everything to do with the word co-signer. a word that implies a signature, a conversation, a document I would have had to physically sign in front of someone, none of which had ever happened. Laura, I never signed anything, Nathan. I've never even seen this loan application. How exactly did my signature end up on it? There was a longer pause after that message, and when his mother, Carol, joined the conversation less than 10 minutes later, I understood that Nathan had immediately called his parents to tell them what I'd found, rather than answering my question directly. Carol. Laura, honey, I know this feels like a lot right now, but you have to understand, this business has supported this family for 30 years. It's family. You don't hesitate when family needs help. I stared at that message for a long moment, struck by how completely it avoided the actual question I had asked. I hadn't questioned whether I was willing to help my in-laws. I had asked how my legal signature had ended up on a document I had never seen, for a debt that was now 4 months delinquent and accruing interest daily. My sister-in-law, Julia, who worked as the office manager for her father's company, and who I had always had a cordial, if not particularly close, relationship with, added her own message shortly after, and it was this message, more than anything Nathan or Carol had said, that told me exactly how normalized this had become inside that family. Julia, can everyone stop being dramatic about this? Nothing bad is going to happen. Dad's business has been through worse cash flow issues before, and it always works out. This is exactly why we don't tell you guys things, because you overreact. I sat down at my kitchen table and read that message a third time, absorbing the specific phrase, "This is exactly why we don't tell you guys things," which implied, with a casualness that genuinely stunned me, that this was not the first time my name, or possibly Nathan's, had been used for something without full disclosure. I didn't know yet what else that phrase might be referring to, but I filed it away, the way I file away every small inconsistency in a witness statement at work, because those small inconsistencies almost always turn out to matter later. To understand why this situation unfolded the way it did, I think it helps to know a little about the family I had married into 6 years earlier. Walter and Carol Bennett had built their business from nothing, starting with a single service van and a used set of tools when Walter was 26, growing it over 3 decades into a company with 11 employees and a reputation, at least locally, for reliability. Nathan had grown up watching his father work 60-hour weeks, watching the business survive 2 recessions and one particularly brutal ice storm that had nearly bankrupted them when half their equipment was destroyed in a warehouse flood. There was a real, earned pride in that history, and I want to be fair in saying I understood and even admired it, in the years before any of this happened. What I also understood, though I hadn't fully articulated it to myself until that September afternoon, was that this pride had calcified, over the decades, into a family culture where the business's needs were treated as simply more urgent, more legitimate than almost anything else competing for attention or resources. I had watched Nathan cancel our own vacation plans twice in the 6 years we'd been married because his father needed help with an emergency commercial job. I had watched holidays get rescheduled around the business's busy season without much discussion. I had, if I'm honest with myself now, normalized a certain amount of that dynamic long before the loan situation ever arose, telling myself it was simply what supporting a small family business looked like. The same story Carol had reached for so quickly in her first text message to me. What I hadn't understood until I was staring at that collections letter was how far that normalization could extend once it moved from asking for my patience and flexibility to using my legal identity without informing me at all. I want to back up here and explain what I eventually pieced together about how this had actually happened, because understanding the mechanism mattered enormously for what I needed to do next, both as Nathan's wife and, frankly, as someone with 9 years of professional experience spotting exactly this kind of situation. 18 months earlier, Walter Bennett's company had gone through a difficult stretch. A large commercial contract had fallen through when the developer backed out midway through a build, leaving Walter's business short on cash flow and behind on payments to his own suppliers. He needed additional financing to bridge the gap, and his existing business credit, while not terrible, wasn't strong enough on its own to qualify for the amount he needed at a reasonable interest rate. The bank's loan officer had suggested a personal guarantor with strong individual credit could improve the terms significantly. Walter and Carol had discussed this at a family dinner, one I had actually attended, though I hadn't understood at the time what the conversation was really about. I remembered Walter mentioning, in general terms, that the business needed some additional financing and that he was looking into his options. I did not remember, because it never happened, any conversation about using my name, my credit, or my legal signature as part of that financing. What I eventually learned, through the fraud investigation that followed, was that Nathan had provided the bank's loan officer with a copy of our most recent joint tax return, which included my full legal name, social security number, and income information, ostensibly to help his father demonstrate additional household financial stability in the loan file. What Nathan apparently did not fully understand, or perhaps understood and chose not to think too carefully about, was that the loan officer, working with an application that already included my personal identifying information from that tax document, filled in a guarantor signature line using an electronic signature process that did not require me to be physically present, verified, or even aware that a signature was being generated in my name. In plain terms, someone at that bank, working from documents Nathan had provided without my knowledge or consent, generated my signature on a legal financial document I had never seen. Whether that was outright fraud on the bank's part, negligence, or some combination of both, was a question I would spend the next several weeks working through with an attorney, but from where I sat that first evening, the distinction mattered less than the plain, immediate fact that I was now legally listed as responsible for $91,000 in defaulted business debt. I did not respond to the family group text again that night. I want to be honest that part of my restraint was professional habit rather than composure, because internally I was furious in a way I hadn't been in years, the specific, cold fury that comes from realizing people you trusted made a calculated decision about your financial future without extending you the basic courtesy of asking. Instead, I spent that evening doing what I would have told any client in my position to do. I pulled my credit reports from all 3 major bureaus and confirmed the account was already reporting, with a derogatory mark that had appeared on my file 4 months earlier, the same month the payments had first gone delinquent, meaning my credit had already been damaged for months before I had any idea the loan existed. I documented every text message from that afternoon with timestamps. I located our joint tax return from the relevant year and confirmed which version Nathan had access to and could have provided to the bank. And I called the fraud department of the bank that had issued the loan first thing the following morning, before I said another word to Nathan or anyone in his family. The fraud investigator I spoke with, a methodical, unhurried man named Gregory, who clearly dealt with exactly this kind of situation regularly, walked me through what the process would look like. I would need to file a formal identity theft affidavit, which I completed and notarized that same week. I would need to provide a written statement confirming I had never authorized, signed, or consented to being listed as a guarantor on the loan. I would need to file a police report, not because Gregory expected criminal charges to necessarily follow, but because a police report number was required documentation for disputing the debt with the credit bureaus and for pursuing any claim against the bank for processing an unverified electronic signature. Before I ever walked into that police station, I spent an hour on the phone with an attorney my firm sometimes referred clients to for exactly this kind of situation, a woman named Denise Okoye, who specialized in consumer financial fraud and identity theft cases. I remember feeling almost embarrassed making that call, sitting in my car in the parking lot outside my own office building on my lunch break, because some part of me still wanted to believe this was a misunderstanding that could be untangled with a single honest conversation, rather than something that required formal legal intervention. Denise disabused me of that notion within the first 10 minutes. The fact that it's family doesn't change what happened, she told me. If anything, it makes documentation more important, not less, because family situations are exactly where people expect the injured party to back down rather than pursue the full process. She walked me through the steps methodically: the identity theft affidavit, the police report, the formal dispute letters to all 3 credit bureaus, the written demand to the bank itself outlining the unauthorized signature and requesting immediate removal of my name from the loan pending investigation. She told me, and I remember this clearly because it steadied something in me that had been shaking since the previous afternoon, that the emotional difficulty of the situation and the procedural correctness of my response were 2 entirely separate things, and that I didn't need to resolve the first before pursuing the second. I filed that police report 2 days later, at the small municipal station near our house, sitting across from a patient young officer who typed my statement into a form on her computer while I explained as plainly as I could exactly what had happened. I remember her asking at one point whether I wanted to include my husband as a person involved in the incident, since he had provided the tax documents that made the fraudulent application possible, and I remember sitting with that question longer than I expected to. I decided, in the end, not to name Nathan in the police report, not because I believed he was innocent of poor judgment, but because everything I had learned by that point suggested he genuinely hadn't understood the mechanism by which his father's loan officer would use those documents, that he had believed, in whatever half-examined way people believe convenient things about family, that providing the tax return was simply a documentation step, not an authorization for anyone to generate my legal signature. I filed the report against the loan itself and the bank's process, and I let my attorney determine separately whether Nathan bore any civil liability for his role in supplying the documents that made it possible. The days that followed the filing were some of the hardest of my marriage, not because Nathan and I argued constantly, but because of the specific, quiet way the conversation between us kept circling back to the same unresolved question, which was whether he understood why what had happened mattered as much as it did to me. "I didn't think it was a big deal," he told me one night, sitting across from me at our kitchen table, the same table where I'd first read Carol's text about family not hesitating. "Dad's never missed a payment on anything in his life. I genuinely thought it would just work itself out before you ever had to know about it." "That's not the point, Nathan," I said, and I remember working very hard to keep my voice level, the same way I keep my voice level in depositions when a witness says something that makes my job significantly harder. "The point isn't whether your dad was going to pay it back. The point is that nobody asked me. You made a decision about my legal identity and my financial future without asking me, because you assumed I would say yes, or because you didn't think my answer mattered enough to wait for." He didn't have a good response to that, not that night and not for several nights afterward. I think, in fairness to him, that he was still working through the gap between what he had believed he was doing, a small, reasonable favor for his father, and what had actually happened, which was that his father's company had used my identity to secure financing I never would have agreed to if anyone had simply asked. Hummy. Before Carol called, Walter himself came to our house, unannounced, on a Saturday morning about 4 days after I'd filed the police report. I remember opening the door and finding him standing on our porch in his work clothes, clearly having come straight from a job site, his expression a mixture of embarrassment and defensiveness that I hadn't seen on him before in 6 years of knowing him. "I think we need to talk about this like adults," he said, standing in our doorway, "instead of you going through the police over something that was never meant to hurt you." I invited him in, mostly because I didn't want that conversation happening on the porch where a neighbor might hear it, and we sat at the same kitchen table where I would later have the hardest conversation of my marriage with Nathan. "Walter," I said, "I want to understand something. Did you know my signature was on that guarantor line before the loan closed?" He was quiet for a moment, long enough that I understood the answer before he gave it. "The loan officer told me the paperwork was handled," he said. "I didn't ask exactly how. I trusted the bank knew what they were doing with the documents Nathan sent over." "So you never actually saw me sign anything," I said. "You never asked me directly if I was willing to guarantee $85,000 of your business debt." "I didn't think I needed to spell it out," he said. "You're family. I assumed if there was a problem, you would have said something before it got this far." I remember sitting with that sentence for a long moment because it captured, more clearly than anything Carol or Julia had said, the actual root of what had happened. Walter hadn't decided to defraud me. He had simply decided that my silence, my lack of an opportunity to object to something I didn't know was happening, could be treated as consent. It was a distinction that mattered enormously to me, both personally and professionally, and one I don't think he ever fully grasped, not that morning and not in the months that followed. "I never had the chance to say something," I told him as evenly as I could manage. "That's the entire point. Nobody gave me the chance." He left about 20 minutes later, without much resolution, though he did say, on his way out the door, that he was sorry it had happened the way it did. I noted, even then, the careful construction of that apology, sorry it happened, rather than sorry he had done it. A distinction I would keep noticing in every conversation with the Bennett family for months afterward. Carol called me directly about a week after I filed the police report, and that conversation was, in some ways, harder than anything Nathan and I had discussed, because Carol's approach shifted from the guilt-based framing of her first text message to something closer to genuine confusion about why I was treating this as seriously as I was. "I don't understand why you had to involve the police," she said. "This is a family matter. We would have figured it out." "Carol," I said, "my credit has already been damaged for 4 months because of a debt I never agreed to. That's not a family matter that gets figured out quietly. That's identity theft, whether anyone intended it that way or not." "Walter would never intentionally hurt you," she said, and I believed that was probably true, in the narrow sense that Walter had likely never sat down and consciously decided to defraud his daughter-in-law. But intention, I had learned over 9 years of reading fraud case files at work, mattered far less than most people assumed it did, both legally and personally. What mattered was the outcome, and the outcome was that I was now spending my evenings on the phone with fraud investigators and credit bureaus instead of doing almost anything else with my time. Julia never called me at all, though she did send one final text message, weeks later, after the investigation had already been underway long enough that the bank had opened its own internal review of the loan officer who had processed the application. "Julia, Dad's business account is frozen and he can't make payroll this week because of your report." I looked at that message for a long time before responding, and I remember feeling, more than anger, a kind of tired clarity about exactly what role I had apparently always occupied in that family's understanding of things, someone whose resources and identity were available to be used when convenient, and whose objections, when they finally came, were framed as the actual problem rather than the underlying misuse that had caused them. "Laura, I didn't take out a loan in my name without asking your dad's permission. He and the bank did that to me. If the account being frozen is causing problems, that's a conversation for your dad to have with the bank, not with me." I didn't hear from Julia again after that. The investigation took just over 2 months to fully resolve. During that time, I spoke with the fraud investigator, Gregory, on 9 separate occasions, each call requiring me to walk through the same sequence of facts: the tax return, the automated signature process, the 4 months of delinquent payments I'd known nothing about, until the story felt less like something that had happened to me and more like a case file I was simply managing, which I think was its own kind of protection, a way of keeping the professional part of my brain in charge while the personal part of me worked through everything happening at home. The bank's internal review ultimately confirmed what my attorney and I had already documented, that the electronic signature on the guarantor line had been generated using an automated process the loan officer had initiated without any verification that I had personally reviewed or approved the document, a clear violation of the bank's own compliance procedures. The loan officer responsible, I later learned through the regulatory complaint process, had processed at least 2 other loans using a similar shortcut, treating supporting documentation as implicit authorization rather than requiring the actual signatory to appear or verify electronically themselves. Whether those other cases involved anything as fraud as mine, I never learned, since that information wasn't something the bank was obligated to share with me. But knowing I hadn't been an isolated incident somehow made the whole situation feel less personal and more structural, which I found, unexpectedly, easier to sit with. The bank removed my name from the loan entirely, corrected the derogatory marks on all 3 of my credit reports, and, following a formal complaint my attorney filed with the state banking regulator, paid a settlement to cover the cost of the credit monitoring service I'd had to purchase and a portion of my legal fees. It took another 6 weeks after that for the marks to fully clear from my reports. 6 weeks during which I checked my credit score more obsessively than I probably needed to, refreshing the same 3 apps on my phone the way some people check the weather. Walter's business, without my name attached as guarantor, had to renegotiate the loan terms directly, which meant a higher interest rate and a shorter repayment window than the original agreement had offered. I understood, from things Nathan mentioned in passing over the following months, that the business went through a difficult stretch as a result, tightening expenses, delaying 2 planned equipment purchases, operating with a leaner staff for most of that following year. I won't pretend I didn't feel some complicated mixture of vindication and discomfort watching that unfold from a distance, knowing that my refusal to simply let the situation resolve itself quietly had real material consequences for people I still saw at holidays. Nathan and I stayed together, though I would be lying if I said that period didn't change something fundamental about how we operated as a couple. We started keeping our finances more formally documented than we ever had before, not out of distrust of each other exactly, but because I made clear, in a conversation that took most of one long Saturday afternoon to have honestly, that I needed him to understand the difference between the 2 of us making decisions together and him making decisions on my behalf because he assumed I would agree. He has, to his credit, taken that seriously in the years since. When his sister asked him, more than a year later, whether he could help co-sign a car loan for her, he told her, before he told me anything about it, that any request involving either of our names required both of us to sit down and discuss it directly with whoever was asking, with full documentation, before anyone signed anything. Walter and I have never fully addressed what happened, not directly, not in so many words. He apologized once, briefly, at a Thanksgiving dinner about 18 months after everything was resolved, telling me he was sorry it had gotten as complicated as it did, and that he'd never meant for it to cause trouble between me and Nathan. I accepted the apology because I believe he meant it, but I also noticed, and still notice, that the apology focused on the trouble it caused between me and his son, rather than on the fact that his business had used my legal identity without my knowledge in the first place. I've stopped waiting for the version of that apology that fully names what actually happened. Some people, I've learned, are only capable of apologizing for the consequences they can see, not the decision that caused them. I think about that collections letter often, sitting on the counter where I first found it, the ordinary Wednesday afternoon that turned into 2 months of fraud affidavits and credit disputes and careful, exhausting conversations about what family actually owes each other in the way of basic honesty. I don't regret filing that report, not for a single day since. I think about what would have happened if I hadn't, if I had simply trusted that it would work itself out the way Carol wanted me to believe, and I think about the version of my credit history, my professional standing, and my own sense of what I'm entitled to expect from the people closest to me that would exist if I had let that happen. What I chose in the end wasn't an attack on my husband's family. It was simply refusing to let my name be used as collateral, in the most literal sense of that word, for someone else's financial risk, without my knowledge or consent, no matter how urgently or sincerely anyone framed it as something family shouldn't hesitate over. If you've ever found out your name or your resources were used for something you never agreed to, I think you understand exactly what that letter on my kitchen counter meant. Not paranoia, not overreaction, just the plain, sobering discovery that being family, to some people, means being available, whether or not anyone ever bothers to ask. I still work in the same job, reading fraud case files that sometimes echo pieces of my own story back to me in ways I wasn't prepared for the first few times it happened. I've noticed, since that September, that I read those files a little differently now, less as abstract legal problems and more as evidence of exactly how ordinary the beginning of a situation like mine can look. A piece of mail, a phone call, a family member who assumed silence meant permission. I don't think I'll ever fully stop noticing that. If this story means something to you, I'd like to know how you would have handled it. Would you have made that call to the fraud department the same day I did, or would you have given your family the chance to fix it quietly first?